on March 21st, 2025, the State Department approved the revocation of a student visa for Pramila Jayapal, a Turkish citizen who is a graduate student at Tufts University, apparently simply for writing an op-ed. According to an internal State Department memo, you took this action under your discretionary authority to revoke visas, and soon after you revoked her visa, armed and masked plainclothes officers snatched Ms. Ozturk off the street and transported her to a prison in Louisiana. Mr. Secretary, do you really think that Ms. Ozturk's op-ed results in a foreign policy consequence for the United States?
I believe that case involves someone whose visa we never would have granted had we known ahead of time.
I'm not asking you that question. I'm asking you if you think an op-ed, but that's exactly, in fact, what happened. The State Department wrote a memo concluding that you did not have sufficient grounds to revoke Ms. Ozturk's visa. There was no evidence showing that she'd engaged in any activities that were a threat to national security. And in fact, in May, a federal court ordered Ms. Ozturk's release from detention, noting that the sole basis for the government's detention appeared to be the fact that she co-authored this opinion piece in the Tufts newspaper in March of 2024. Where in the Constitution does it say that the Secretary of State can override the First Amendment protections of free speech? Is there a footnote that I missed somewhere?
There's no constitutional right to a student visa.
So, but is there a constitutional right? Does it say somewhere that Marco Rubio gets to determine which speech is appropriate and revoke student visas based on what you think constitutes free speech?
There's a statute that says the Secretary of State gets to determine whether someone is a threat. We deny visas every day all over the world.
Do you think that the Immigration and Nationality Act trumps the Constitution of the United States, Mr. Secretary?
Well, Congress can always change the law if you want, but I'm telling you,
Mr. Secretary,
while I have the authority, I will continue to revoke the visas of these people that come here to tear this country apart.
You said that, Mr. Secretary. Let me reclaim my time, because you are talking about revoking student visas based on what somebody says. And that means that you are trumping the legal Supreme Court, the supreme law of the land, which is the Constitution of the United States.
No one has a right to a student visa.
Mr. Rubio, why did the administration need to use masked, armed, unidentified agents to whisk somebody off the street and deny her counsel for almost 24 hours after her arrest?
Well, you'll have to ask the agencies that did that work. I'm not responsible for that. I'm responsible for revoking the visas of these people that come to tear this country
Rubio,
apart.
I'm talking about this particular case where you revoked the student visa of a Turkish citizen who was a graduate student who wrote an op-ed that you didn't like. And suddenly you allowed for masked men to whisk her off the street. And you have multiple jobs, apparently. You're the national security advisor as well. So don't tell me it's not your job who snatches her off the street.
We don't do the snatching, but I can tell you we do the visa revocations.
Let me ask you about the national security consequences of people, masked men on the streets, snatching people off the streets. If these are legitimate law enforcement agents carrying out proper arrests, why are they hiding their identities?
Because then radical crazies will try to hurt them.
So you think that U.S. agents who have almost always gone without face coverings, even when they're arresting some of the country's most dangerous criminals, suddenly have so much to fear from a graduate student who wrote an op-ed that they need to be masked? Is that
that law student was a guest in the United States on a student visa. No one's entitled to a student visa.
So you revoked her student visa based on an op-ed which trumps the supreme law of the land, which is the Constitution.
Someone's coming up here to stir up problems on our campus. We're going to revoke their visa.
She didn't do any of that. She wrote an op-ed. Well, she wrote an op-ed, and I'm talking to you about her particular case.
Claims and your claims. Those are not the facts.
Reclaiming my time, you revoked her student visa because
proudly.
she wrote an op-ed.
Would you revoke? We're going to do more.
I have another question for you. Would you revoke the visa of someone in the United States who published claims that, quote, Jews are an untrustworthy and dangerous group? Yes or no?
We will revoke the visa of anyone who's in this country as a guest who's here to stir up trouble.
Are you going to revoke the visa of somebody who made that?
I mean, the case. I'll look at it. I'm looking to get crazy people out of our country.
It's not just about revoking.
You actually,
Secretary Rubio, excuse me, reclaiming my time. Can you explain to me why the Trump administration granted refugee status to Charles Kleinhaus, the white Afrikaner who tweeted that exact statement that I just said? There's the case.
That's not a visa.
You granted You granted that person
That's
to
a
enter the
totally
United
different process.
States.
That's someone that applied here through a totally different process.
Secretary Rubio,
student visas are a privilege.
Secretary
we deny
Rubio,
them all the time, and we'll
you
revoke them.
revoked
And
a visa based on an op-ed, and then you allowed for
Gentlelady's time
masked
has
men
expired.
to
that's your
snatch
claim. That's
somebody off
accurate. That's
the
your claim.
street.
Your time's
That's your claim.
expired.
That's your claim. That's not accurate.
This hearing was officially about foreign policy and visa authority. But what unfolded inside the House Foreign Affairs Committee was something much deeper: a direct constitutional clash over free speech, executive power, immigration law, and whether the government can punish political expression by non-citizens studying inside the United States. Representative Pramila Jayapal approached Secretary of State Marco Rubio with a highly specific and emotionally charged case: the revocation of a student visa belonging to Turkish graduate student Rümeysa Öztürk after she co-authored an opinion article connected to campus activism. And almost immediately, Jayapal framed the issue not as immigration enforcement, but as a First Amendment crisis. That framing matters enormously in the United States. Americans may disagree sharply on immigration policy, student protests, or campus activism. But constitutional free speech protections remain one of the country's most culturally powerful political values across the ideological spectrum. Jayapal's strategy was to repeatedly force Rubio into answering one central question: can the government revoke a student visa because it dislikes someone's speech? Rubio answered from an entirely different framework. His core argument was straightforward: a student visa is not a constitutional entitlement. It is a privilege granted under immigration law, and the Secretary of State possesses broad statutory authority to revoke visas if an individual is deemed harmful to U.S. interests. That legal distinction is critical. Historically, courts have recognized that non-citizens seeking entry into or remaining within the United States do not possess the exact same constitutional protections as citizens in all immigration contexts. Federal immigration authority, especially involving visas, removals, and admissibility, has traditionally given the executive branch enormous discretion. But Jayapal was not really arguing technical immigration doctrine. She was arguing something broader. That political speech itself appeared to be the trigger for government action. And that is what transformed this hearing into a much larger constitutional and political conflict. Jayapal repeatedly referenced the State Department's own internal memo, the absence of evidence tying Öztürk to national security threats, and a federal judge's later comment suggesting the government's actions appeared tied directly to her co-authorship of an opinion article. That matters because the hearing increasingly became about precedent. If the executive branch can revoke visas over political speech it views as dangerous or disruptive, critics worry the standard itself becomes highly subjective. Rubio leaned heavily on national security and public order language throughout the exchange. He repeatedly argued the administration would revoke visas from people who come to the United States to tear this country apart. That phrase was politically significant. It reflects a broader post-October 7 political shift in Washington where campus protests, anti-war activism, and rhetoric surrounding Israel and Gaza have increasingly become tied to debates over antisemitism, extremism, foreign influence, and national security. In recent years, universities across the United States have become major battlegrounds over speech, protest rights, and political activism related to the Israel-Gaza conflict. Multiple lawmakers and administrations have pushed universities to respond more aggressively to demonstrations viewed as threatening or extremist, while civil liberties groups warn that governments and institutions risk suppressing protected political expression. That larger backdrop shaped this hearing profoundly. Then the exchange became even more controversial. Jayapal shifted from legal theory to optics and enforcement tactics. She questioned why masked federal agents allegedly detained Öztürk in public and why she was reportedly denied legal counsel access for nearly 24 hours afterward. This section struck at something emotionally powerful for American audiences: fear of anonymous state power. Historically in the U.S., visible law enforcement identification has been associated with public accountability. So images or descriptions involving masked agents immediately trigger broader concerns about civil liberties, government transparency, and abuse of authority. Rubio defended the practice by arguing agents face growing threats from extremists and political violence. That explanation reflects a real trend. In recent years, threats against federal agents, judges, election officials, and public servants have risen sharply across the political spectrum. Some agencies have increasingly adopted protective measures because of fears involving doxing, targeted harassment, and political violence. But Jayapal's counter-argument was equally significant. If the government uses masked agents against non-violent students involved in political speech, the symbolism itself can appear authoritarian to many Americans. And symbolism matters enormously in modern politics. One of the most revealing moments came when Jayapal accused Rubio of effectively placing immigration statutes above constitutional principles. Rubio responded by repeatedly emphasizing that Congress itself granted the Secretary of State this authority through federal law. That exchange exposed one of the deepest unresolved tensions in American constitutional governance. How much discretion should the executive branch possess in immigration matters when constitutional rights and political speech intersect? Courts have wrestled with versions of that question for decades. And the issue is becoming even more explosive as immigration enforcement increasingly overlaps with campus protests, ideological activism, national security concerns, and social media speech. Jayapal then introduced another politically loaded comparison involving refugee treatment and controversial statements allegedly made by a white South African refugee applicant. That move was strategic. She appeared to be arguing the administration applies ideological standards inconsistently depending on political alignment, nationality, or perceived cultural threat. That accusation reflects a broader criticism frequently aimed at modern immigration policy. That enforcement decisions are not always politically neutral. Whether viewers agree or disagree, the hearing revealed something unmistakable about the current American political climate. Immigration debates are no longer just about borders. They are now deeply intertwined with free speech, protest movements, campus politics, national identity, executive authority, and constitutional interpretation itself. And that is why exchanges like this resonate so intensely. Because underneath the procedural argument about visas was a far larger unresolved question. Can the government restrict or remove non-citizens based partly on political expression without undermining America's broader commitment to free speech principles? That debate is far from settled. Especially as courts continue reviewing cases involving campus demonstrations, immigration enforcement, executive discretion, and the constitutional limits of national security authority. What do you think? Should the government have broad authority to revoke visas for foreign nationals involved in politically controversial activism, or does that risk undermining core American free speech values? Leave your thoughts in the comments below. And if you value long-form congressional analysis that goes beyond headlines and examines the constitutional, political, and institutional battles shaping Washington, subscribe to Capitol Oversight for more deep oversight coverage and hearing breakdowns.